Beginning, I want to introduce who is here. I'm Wally Dietz, Director of Law. I think you all know that. With me is Laura Fox, Associate Metropolitan Attorney, Cindy Gross, Associate Metropolitan Attorney, Felinda Ramsey, Assistant Metropolitan Attorney, Senior Assistant, and we all have been involved in the Covenant School shooting case, the tragedy that occurred on March the 27th. We have been involved on the back end, working with the police, working with requests for document production. We have all been on the receiving end of dozens of media requests, and that's been fine. We welcome those. I thought it would be helpful to get people in a room today so that we can answer questions all at once. There are some things we're not going to be at liberty to talk about, and we'll get into that as we go along. We don't anticipate taking much of your time, but I thought it would be helpful from the outset for Laura Fox, who is our lead attorney in the courtroom today, to walk through the history of what's happened in this case. Obviously, the tragedy was on March 27th, and then Laura will pick up with the history of the public records requests, what has been done since the first request came in, and bring us up to today, and then we'll come back and say a little bit more.
Sure. My name is Laura Fox. I'm glad to be with you here today. After the shooting, there were many public records requests, and those requests were denied based on the Tennessean case and this Rule 16th exception that the Tennessee Supreme Court has created for ongoing criminal investigations. There were some parties who were not satisfied with that response, so Clatta Brewer filed a lawsuit. Soon after that, she was joined by the Tennessee Firearms Association. There was another lawsuit filed by Mr. Leahy and Star News, and then just last week, the Tennessean filed a lawsuit along with Senator Gardenhire. And all of those lawsuits at this point have been consolidated into one lawsuit, so all the cases are in front of Chancellor Miles. At the same time, or very close thereafter, the Covenant School, the Covenant Church, and the parents of the victims, many of the parents, the great majority of them, also hired attorneys that have moved to intervene in the lawsuit. And so they asked the court, part of today's proceedings was to ask the court for them to be able to make their position and make their arguments based on the Tennessee Constitution, which contains special provisions for victims' rights. That decision is the court took that under advisement, so we don't know quite yet whether or not those entities will be able to intervene or not. There is currently a show cause hearing set for June 8th, and the court intends to stay with that date. Although the court is going to conduct an in-camera review, that means a review where the judge looks at it in their chambers, or in this case, I think the judge will be going to MNPD's offices to review the documents in the case. And so the judge is going to issue an order on Wednesday that will resolve the motions to intervene and will tell us what is the briefing schedule and then whether or not the June 8th date is still possible to stick with.
So thank you, Laura, for that brief update. Under the rules, the local rules of court, it's inappropriate for us to argue the merits of our position relative to which documents should be produced and which should not. All of those are in our court filings. We've tried to make all of those available to you. We're not here to make legal arguments. But we are here to answer any process questions that you have. Some of this will be predicting the future, which is difficult for all of us in a case like this. But we will be able to hopefully answer some of your process questions. Before we get to those, there's one additional comment that I want to make in my personal individual capacity, not as law director or speaking for the metropolitan government. And that goes to a filing that the Tennessean filed last week, late last week. The Tennessean filed a petition to intervene, which was granted, and they have the right to intervene. Of course, they have the right to intervene and assert their rights. In that petition, the Tennessean made several arguments. We don't agree with a lot of those arguments, but that's what the court is for. That's all fair game. And in their filing, the Tennessean also asserted the threat of a claim. They call it the Reverse Public Records case, Reverse Public Records complaint, where they have threatened to sue the metropolitan government for interfering with their constitutional rights to review these documents. You know, that's fair game. We don't agree with that. We don't think our actions have interfered with any rights. They have. In fact, we did what we did in this case because we believed that there were parties who had rights, and those individuals and institutions needed to have the right to petition the court and be heard, and they were today. We were worried that parents of victims, parents of students, and it's our position that all students at that school are victims. We believe that those parents and family members should have the right to have a say in what documents get released and don't. We believe the church and the school each has a right to be heard, and the Tennessean has said, well, we don't think that's appropriate, and we may sue you for attorney's fees and expenses under a particular state statute. Well, that's fine when you're talking about Metro, but they also threatened to sue the parents and the church and the school for those costs and attorney's fees. And on a personal level, I would hope that the Tennessean would think twice about asserting that allegation against the parents and the church and the school, who are the victims of what our mayor has called the worst day in Nashville's history. And so I wanted to put that point out there. It's a personal request. If they have a claim, we have plenty of money to pay a claim if they are right at the end of the day. Let's leave the other parties alone. Thank you.
Any questions?
I have a question. So you were sort of addressing why you invited these parties to intervene or to have a say. I mean, is that true in all cases? Do you think crime victims or adjacent people should be able to intervene and argue that records shouldn't be released?
It is something that we try to do in every case. If we believe the government is holding records that someone has a personal interest in, there are things that we do automatically. We redact social security numbers, things like that. We will do that automatically, but we do try to ask people if they have a right that they want to assert relative to certain documents. 99% of public records requests go through automatically without any of that happening other than a redaction of clearly identifying confidential personal financial information. But this is an exceptional case, and one reason it is because of the Vanderbilt rape case in 2016, when the Supreme Court and the Court of Appeals, Supreme Court affirmed a Court of Appeals finding that the victim in that case had rights. And the victim intervened in the case to try to prevent certain documents that were in the police records from being produced to anybody. And the court recognized those rights. So since that case, we have focused on victims' rights, and we believed that victims, family members, victims' families, the school itself was the victim of an assault. And so we believed that there were certain rights that they may want to assert that we may or may not have standing to assert for them. So the only thing we tried to do was to take a little bit of a pause so that they could come in and hire lawyers if they wanted to, and they did, and then have the lawyers present their case to the court. We believe that was appropriate, and we will defend that decision. It was a decision Metro Legal made. It was our decision. We made it, and we believe it was the right thing. And we'll see what the court does with the petitions to intervene. But it was our decision to slow this down to give them enough time to talk to a lawyer and file some papers with the court to protect their rights if they believed they had rights that needed protection. And we'll defend that decision until the end of the day.
And those are rights you believe Metro could not assume?
It's unclear. It's unclear. Metro itself does not have victim rights. This was a private school. It was not part of MNPS. I'm not saying we would never have rights as a victim, but in this case, it was unclear to us, and it seemed doubtful that we had the right to assert victim claims for these individuals and families, and which is why we invited them to discuss that with their legal counsel, and they did.
Mr. Gates, can you tell us who all has seen this journal that we're talking about? There was conversation today that maybe the parents are trying to hide something, and there was someone else mentioned that some of it's been reported or documented and is out there. Can you tell us who all has actually seen this unredacted journal that's in the hands of the judge now?
Okay. The four lawyers standing up here, the Metropolitan Police Department, the TBI, the FBI. I'm not aware of anyone else.
And the judge.
And the judge, obviously the judge. We filed it on May the 12th, so the judge. These documents are in the hands of the TBI and the FBI. And I would point out that Senator Gardenhire has filed a lawsuit with Tennessean to seek the records. There's a state law that permits any legislator to go to the TBI office and look at any investigative file they have. So if Senator Gardenhire wants to see this file, he can drive to the TBI and they will show it to him. So he didn't need to file a lawsuit. I'm confused what that's all about. But he has a statutory right, as does every member of the legislature, to go ask the TBI to look at this file. We're not trying to hide this from anybody, but we do. There is some really sensitive information in there that we believe should not be produced based on school safety and the fact that there is still an ongoing criminal investigation. So it's simply not accurate to say there is no ongoing criminal investigation. That was made clear today in court, but I'm gonna stop there.
So these state reps that are calling for it, they could actually go access it themselves now?
I'm sorry, say that again.
So you're telling me that these state representatives that are calling for the quote manifesto to be released, they could actually go to the TBI and access this themselves now?
There's a state law that makes that clear. Yes.
The court seemed to be a bit surprised that after your May 12th filing, assuming coming shooter's journal, that there were going to be no more records produced by Metro on a rolling basis. And it seems like that could potentially mean that you may show cause hearing back. Why was the judge not informed of the other parties that documents weren't going to continue to come in and we settle no 3 hours before the
All of our communications with the judge have been in filings with the court, and we thought the status conference was an appropriate time to bring this up. The declarations filed by the police indicate that this could take months, if not an entire year. And we stand on the declarations that say there is an ongoing criminal investigation. So we are happy for the court to go look at this file and make a determination whether the court agrees that there's an ongoing criminal investigation. That's appropriate. But at this point, we're not in a position of doing a rolling production of documents because the police have not concluded their investigation. It's not a normal case. A normal case for public records is asking for records of government activity. And in that case of requesting government activity, we will look at the volume and tell the requester, we can produce a certain amount of documents by this date, and then we'll do a rolling production, but we estimate it will take this amount of time. Sometimes for the really, really large document productions, it can go on for months based on the volume of documents. So this is not unusual at all.
Could you say, without identifying specific documents, how many records were turned over to the judge on that May filing date?
I'm not going to answer any specific questions about what we filed under seal, other than to say what we filed under seal were the written statements of the assailant found in her car in the parking lot.
How confident are you guys in this lawsuit?
How comfortable?
How confident are you guys in this lawsuit?
How what?
Confident?
Each party has a role to play. If you look at it from the Tennesseans' point of view and the petitioners, they believe their right to see public records is unfettered, and that they should get all of these records immediately. If you look at it from the point of view of victims and their families, they may wish that these records never be produced. I believe that we have taken positions in good faith that should be upheld by the court. But again, I'm not here to argue the merits or to try to influence the court or even the other parties. What I will say is that this is a very interesting confluence of First Amendment rights, public records access, rights of victims. It's just a really interesting case, and some of these issues have not been litigated fully. So I'm as confident as I can be. The positions we have taken are 100% supported by the law. But we are in territory that has not been litigated extensively.
Just here in Tennessee or across the board, would you say that it has not been litigated before? Is this new ground for you guys or for the country or just for Tennessee?
Well, I know in Tennessee, the only case that's close to this is the Vanderbilt rape case, where the victims' rights were recognized. I can't say I'm familiar with litigation around every mass shooting public records request, so I can't say. I'm not aware of courts having to struggle with the issues the chancellor was dealing with today.
We need to go.
Any other questions?
Yeah. All right. Thank you all. I think it's time for us to go.